Hello and welcome to TIOL Tube's Legal Wrangle. Every day, scores of legal decisions from various courts and tribunals are virtually pouring in. As a tax practitioner, consultant and student, you need to be on top, plodding through hundreds of decisions or even head notes a few pages long. But come on, this is the digital age where everything you want today was needed yesterday. And this is where legal wrangle comes in. We understand tax and value your time. So, for the first time in India, we bring you digital head notes that are crisp, clear and concise. You can now close your eyes and hear the head notes on the go. Legal Wrangle is a weekly roundup of all the important decisions covering direct and indirect taxes. These are the decisions you want to know to deliver today what is needed tomorrow.
Hello and welcome to Legal Wrangle, TIOL Tube's weekly program on direct and indirect tax cases. To begin with, let's go to the Delhi High Court decision in the case of BOUGAINVILLEA Multiplex Entertainment Centre. The High Court resolved the dispute on whether entertainment tax subsidy is a capital receipt or a revenue receipt, which is not taxable. But first, let's hear from Maneet the facts of the case and what the court ruled.
The assessee is BOUGAINVILLEA Multiplex Entertainment Centre. It runs a shopping mall known as Spice World in Noida. I'm sure everybody's been there. The assessee had claimed deduction on the entertainment tax exemption received as subsidy under a state government scheme for construction of new multiplex cinema halls.
The assessee claimed the entertainment tax exemption as a capital receipt. The revenue insisted it was revenue receipt and taxable.
The Delhi High Court applied the purpose test to determine the character of the subsidy as laid out in the landmark Supreme Court ruling in the case of Sahane Steel, wherein incentives were linked to production for sales and therefore considered as revenue receipt. The court also considered the Apex Court ruling in the case of Pony Sugars, in which subsidy was to be utilized for repayment of term loans taken for setting up new units. The High Court held that entertainment tax exemption was for setting up new multiplex cinema halls and came to the assessee only after the cinema hall had started functioning. Thus, the subsidy was a capital receipt and not liable to income tax. The revenue appeal was dismissed with observation that department had undertaken no exercise to find the expenditure actually incurred by the assessee for setting up the cinema hall to make it functional. This was necessary to assess the extent of capital subsidy assessee could claim over the years of account of entertainment tax exemption.
Thank you, Maneet. This will certainly provide relief to cinema hall operators overcome financial stress from the onslaught of pirated DVDs and encourage more multiplexes in the city. Happy viewing! Well, our next case is also a Delhi High Court decision in the case of the GE Group companies. The High Court considered the question on the liability of an enterprise to suffer interest under Section 234B. This is the case of a foreign company that directed its Indian PE not to deduct tax at source as its income was not liable to tax in India. But later, it accepted the tax liability. Can a company do a volte-face without suffering the consequences for non-payment of advance tax? Or is it the payer with absolute obligation to deduct tax at source? The High Court considered two contrary decisions quoted as precedents. It weighed its decision in the case of Alcatel and also in the case of Jacobs. But let's turn to Maneet for the facts of the case.
The foreign assessee is the GE Group of companies. 8 companies belonging to the General Electric Group manufactured equipment for supply to customers in India through its Indian permanent establishment, as in the PE. These foreign assessees file nil returns of income.
The assessing officer held that assessees had a permanent establishment in India. Therefore, each assessee's taxable income was computed by attribution of profits to the PEs. on the basis of the percentage of sales price of equipment. Interest under sections 234A and 234B was also levied for failure to pay advance tax in terms of section 208 and section 209.
The Commissioner Appeals confirmed the AO's order. However, regarding chargeability of interest under section 234B, the Commissioner applied the decision of the Delhi High Court in the case of Jacobs. The interest was deleted. The tribunal dismissed the revenue appeal on the issue of interest. Not losing heart, revenue went before the Delhi High Court. Revenue insisted that the levy of interest under section 234 being mandatory, assessing officer has no discretion.
The Delhi High Court in case of Alcatel had held that interest under section 234B could be imposed on a foreign company which had initially denied its tax liability for non-payment of advance tax and erroneously caused the payer to refrain from deducting tax at source. The foreign company's role in non-deduction of tax at source by the payer could be presumed, and interest under section 234B was payable.
The Delhi High Court made the differentiation, distinguished the Alcatel case, followed the Jacobs case, and held in favor of the assessee company. The Delhi High Court considered the pre-amended section 2091D and its amendments prospectively with effect from April 2012.
The Delhi High Court held the Alcatel case would not apply because if the payer deducted tax at source only when the assessee admitted its tax liability, then deductions would not be made in cases where assessees either falsely or under a bona fide mistake denied the tax liability.
Thank you, Maneet. The answer is payers beware. For any failure to deduct tax at source from a foreign remittance, it is the payer who will be held as the assessee in default. When the assessee denies its tax liability, the payer is obliged to apply to the assessing officer to determine what portion of the remittance may be deducted at source as tax. Well, I'm hungry now. We have another Delhi High Court decision in the case of food giant Yum Restaurants India. The assessee is an Indian subsidiary of a foreign company that runs two popular restaurant chains in India, Pizza Hut and KFC or Kentucky Fried Chicken. This case deals with duty credit benefits available to Indian service providers with foreign exchange earnings under the Served from India scheme of the Ministry of Commerce and Industry, and it is designed to promote export of services. But first, let's turn to Maneet for the facts of the case.
Well, I'm hungry too. Shall we order pizza? Well, before that, the case. The Delhi High Court faced the issue whether subsidiaries of foreign companies are eligible for benefits under Served from India scheme and whether it is open for the DGFT to interpret the foreign trade policy to exclude non-resident companies from the benefit of SFIS. The Director General of Foreign Trade had disallowed Yum Restaurants India from availing the exports benefits on the ground that the scheme was designed to promote Indian brands only and not foreign brands from India. The High Court ruled in favor of Yum Restaurants.
The Delhi High Court held the DGFT's view that Indian companies with foreign equity are not Indian is erroneous and against the established canons of the Companies Act.
The Delhi High Court granted relief to Yum Restaurants, holding that it was entitled to avail benefits under the Served from India scheme.
Served from India scheme. Well, this decision will benefit hundreds of service exporters having foreign equity but earning foreign exchange for India. They can now avail the benefits of this scheme. Don't forget to log on for our next episode of Legal Wrangle next week. We look forward to your feedback, quips, comments and criticism. Do write to us at editor@tiol.in. Have a good week.